Paul, what do we think? Are we ready? Okay. All right, good evening, everybody. I'd like to go ahead and call the June 13th meeting of the Dunwoody Planning Commission to order. It's approximately 6 p.m. I want to welcome everybody. Got an interesting agenda tonight. We've got regulations about drug rehabilitation centers and a text amendment regarding something that many people consider a drug. So should be interesting. First, I'd like to go ahead and call roll, please. We'll start with my right.
Scott Brown.
Elizabeth Shen.
Deb Cameron.
Debbie Gordon.
And I'm Thomas O'Brien, and I see making her way up to the dais is Commissioner Harris. So, oh, and Commissioner Edmondson. We've got a full house tonight. So awesome. Welcome, everybody. We're glad you're here. First order of business for the evening is to take a look at and dispose of the May 9th, 2023 minutes. Has everybody had a chance to take a look at those? All right. Well, if everybody's had a chance to look at them, we'll certainly entertain a motion on the same.
Motion to approve.
All right, Commissioner Shin moves to approve. Is there a second?
Second.
Commissioner Cameron seconds. We've got a motion and a second. Is there any debate or discussion? All in favor of approving the motion, raise your hand. All opposed, like sign. Looks like it carries unanimously. All right, done and done. So for our next order of business, you won't see any indications that there's something special to be heard, but under organizational and procedural items, Paul is going to give us a brief update regarding some recent city council decisions, in particular regarding some items that have come before this body. And we've kind of talked about doing this so we can kind of come full circle on some of these issues that maybe we don't see the end of. Now we get to, and maybe it'll help us add value in the future too. So Paul, take it away. Thanks.
Good evening, Mr. Chairman. Good evening, commissioners. We had requests from you all to sort of close the loop, so to say, on the cases that are before you, to give sort of feedback on what happened at City Council with these cases. And I would like to do that today for the first time. I'll go through it relatively briefly, but if you all have any questions, let me know. The cases in the last 2 months that were decided by the council was the personal care home at 1822 Mount Vernon Road. You may remember that, that there were conversation with the neighbors at the time. The city council ended up denying this unanimously. There was a special land use permit for the Marcus Jewish Community Center. That ended up being approved yesterday with additional methodology for noise measurement. That was the one where they submitted a noise study at the last minute that was fairly complex. So that ended up being fleshed out sort of up to the city council meeting and between the two city council reads. Yeah, and if you remember, like there was a resident who lived adjacent to the facility. The MJCC actually sort of reached out to that lady, and she came out in support of the special land use permit. So they did reach out to the neighbors and were successful with that. And then we had text amendments. We had 4 text amendments. One with regards to the state zoning procedures law that was approved. Then water efficiency regulations, those were approved too. Both of those were mandated. Third one was parking for home occupations. There was some discussions around the specific vehicle type. If you remember, this was for what type of vehicles can be parked on site. We ended up going, instead of a federal definition, we ended up going with the state definition that we have in the state code of Georgia. That's a bit easier to pull and identify. And then finally, the non-conforming uses. If you remember, like we made some changes to that to close loopholes there, and that ended up being approved as well.
Paul, thank you. Does anybody want to ask anything of Paul, any refinements to this? I think it's probably worth knowing where we kind of were in agreement with the ultimate decision as well as disagreement, so we can have looks at that and understand maybe how we can tweak and improve our process as well. So I would ask everybody to note that. But if anybody has questions for Paul about the same, now would be a great time to ask. Okay, hearing none, we'll go ahead and move forward. Unfinished business, Paul?
None.
Okay, well, then we'll go ahead and plow forward with new business. The first order of business being a review and consideration of a text amendment to create regulations for drug rehabilitation centers or other facilities for treatment of drug dependency. Thank you.
All right, I will do this one. This is a text amendment that changes multiple sections in the code. So you'll see in the ordinance, the proposed code, you see changes to where we introduce a new definition, we introduce a new use to the code, and we introduce it in the use tables. Given how our code is structured, we have four separate use tables, one for the residential districts, the non-residential districts, the perimeter center districts, and Dunwoody village districts, and you'll find changes to all four of those to introduce this new use. The use is not entirely new to our zoning ordinance because it's referenced in 4 sections in our code. Those are the procedural sections that deal with special land use permits and with rezonings. Those require a public hearing at least 6 months and not more than 9 months before the final action for rezonings. So for in front of the city council. So they have increased timeline for these uses and then provide increased public notice requirements as well. This mirrors items that are in the state law and that was copied in there. At the time when this was introduced, which was about 8 years ago, it was not incorporated into the use table. It was not given a definition. So we have the use described in sections of our zoning ordinance, but we don't have it defined and we don't have it sort of given specific zoning districts where it can happen, which opens us up for uncertainty and potential liabilities. So we're trying to fix this now. City Council has issued a moratorium on these uses, which currently runs through August 16th to give us time to adopt regulations. So what we're proposing is, or like that generally what we're dealing with is these are people with drug addiction issues, and the code includes alcohol addiction issues as well, who are undergoing a supervised drug rehabilitation program. So this is a residential program where people come to get help with these addiction issues. Those people are, once they seek help, a protected class under the ADA, sort of under the Americans with Disabilities Act. So they have protections. What we were proposing to regulate with this text amendment is residential programs only. So those are programs where people stay either short-term or long-term in their like outpatient services, which are also fairly common. Outpatient services will not be regulated as part of this. This is purely for the residential components. The outpatient services will be regulated as medical offices. What we're proposing to do to make sure that we're not providing sort of undue restrictions on those people is to follow the existing standards that we have in the code for transitional housing facilities. We selected that because it's similar in terms of its land use impacts. Those transitional housing facilities, which can be used for people who sort of emerge from homelessness and get a place where they can stay for a while. Similarly, can be short or long-term, but are generally not permanent housing solutions. And this also matches what the state of Georgia has in its code, where it groups both of those. It groups both of those together for public notice requirements. We're providing a definition here. So like a drug rehabilitation center is an establishment predominantly or exclusively providing wellness or treatment service to those dealing with diseases related to alcoholism or drug addiction. These include residential or lodging component with overnight stays, whether short or long-term. And then those not offering overnight stays shall be regulated as medical services. So we're specific in that that something that does not provide overnight stays does not fall under this category. And we're proposing a two-part approval process here. So it'll be a permitted use in certain districts, which are C1, CR1, and C2, which are generally our commercial districts. And then under a special land use permit in these other districts. This mirrors the group homes that I referenced before. So this mirrors exactly what we have sort of on the book for those. And I'll show briefly what this means in practice. This is the Dunwoody zoning map, and it's by and large color coded. The same way like zoning maps all over the country are color coded. These are like the districts C1, CR1, C2. They generally are commercial districts, and they're like what you tend to consider shopping centers or retail districts. So we have those in various parts of our city. These facilities will be permitted use here. We have the multifamily residential districts. So those are generally our multifamily districts or apartment districts. We have a few other districts where multifamily can occur, but by and large, the apartment facilities in be it Perimeter Center, in Georgetown, and in along Peachtree Industrial Boulevard tend to be sort of zoned residential multifamily. It'll be a special land use permit in those districts. We have the OI and OIT districts. That's our office institutional districts. So those are like your general office complexes through sort of a DeKalb County approval processes. In the 2000s, we have a fair amount of apartment buildings or multifamily buildings that are ONI2. So from a protection standpoint, we tend to not just look at ONI for the office institutional, but also for the residential component, just because we have a lot of existing facilities. Perimeter Center districts. So we have it as a special land use permit in PC2, PC3, and PC4. Those, for historic context, when we created the Perimeter Center districts, we didn't rezone the entire Perimeter Center area. So those only get activated if someone actively rezones to them. So we only have a few properties that are actually zoned PC2. And you see the majority sort of our retail complex Perimeter Mall, for instance, is zoned C1, which is our commercial district. And then finally, the Dunwoody Village districts. And there we rezoned the entire Dunwoody Village area into the new districts, and it'll be a special land use permit in the DV2, DV3, and DV4 districts. I have those slides ready if it's of interest. And with this, I'll finish the staff presentation.
Okay, thank you, Paul. Since there is no applicant, but this is a public hearing, we're going to offer individuals the opportunity 10 minutes to speak in favor of this change. Well, we're going to start with in favor, and if we hear none, then we'll hear against. Will anybody be speaking in favor? Hearing and seeing none, we'll go ahead and call up those who choose to speak against. You'll have 10 minutes, please. Please identify yourself for the record as well. Thank you.
My name is Stephen Katz. I'm an attorney and I represent Dunwoody Recovery Place. Its group of companies are right next door, actually, and provide have over 200 employees in the city of Dunwoody. And they provide mental health services to individuals who need that. I rise in opposition to the definition that's set forth here because it doesn't do what the intent, the announced intent is. As I understand it, the purpose of this regulation is to regulate drug treatment facilities. That is, facilities that treat people with drug dependencies. Simple. If your exclusive purpose or your predominant purpose is to treat people with drug abuse or substance abuse problems, then you fall within this definition. But that's not what the definition says. And my objection is that the definition says establishment predominantly or exclusively providing wellness or treatment services to those dealing with diseases related to alcoholism or drug addiction. I have no idea what that means. Diseases related to alcoholism and drug addiction. And that could mean anything. That could mean Hep C, cirrhosis of the liver, HIV, diabetes, dementia, Alzheimer's, hypertension. It could include mental health issues where a person may be at risk for substance abuse, but has never been a substance abuse, never had any kind of substance abuse. So what you're saying here with this regulation is we're going to regulate treatment centers that have anything to do with any possibility of any relationship to alcoholism. And to correct that, all you have to do is delete after those delete with diseases related to. Because that's not what you're after. You're after two specific diseases here. So establishment predominantly, or it would read this way, establishment predominantly or exclusively providing wellness or treatment services to those dealing with alcoholism or drug addiction. Then you're not sweeping so broadly with your definition, which is going to be subject to challenge. What you're saying is, hey, we just want to limit drug treatment centers, drug rehabilitation centers. I think this definition would cause considerable difficulty later because you would be essentially giving city employees the duty to decide which diseases are related to drug and alcoholism, drug substance abuse and alcoholism. And I'd be happy to answer any questions that you have, but that small change, I think will protect the city.
Thank you. Is there anybody else who wishes to speak against for the remainder of the 10-minute period?
Excuse me, sorry. Hi, I'm Andrew Merker. I'm the CEO of Southern Live Oak Wellness. You probably drive by my building. I'm at Mount Vernon. We're a mental health outpatient program. We also have Dunwoody Behavioral Health Center off of Brookline? No, what's the name? Barclay. Thanks. Sorry, public speaking, not my thing. Anywho, the reason I wanted to be against this is because the state of Georgia does not define alcohol as a drug. And if you guys want to supersede what the state defines as a drug, I feel that there will be countless issues in any operation, whether it's C1, OI, RM, doesn't make a difference. Alcoholism is not a treatable condition in the state of Georgia because alcohol is not a drug in the state's eyes. And if you guys define alcohol as a drug, we are in confliction with the state and their regulations as it reads. The next topic of medical marijuana, maybe that's going to change things and that becomes drug. I don't know, but clearly defined in Rule 111.17-134 is the DATPE, which defines that alcohol is not a drug, to where if you guys feel that it is a drug, it would only be a drug in the city of Dunwoody. And that's where I'm against the verbiage connected to alcoholism being able to be treated at a drug dependent facility. Thank you.
Thank you. I imagine we have some more time here. Is there anybody else who wishes to speak against? All right, well, at this time, I think it's appropriate that Planning Commission have the opportunity to ask questions of those who've spoken with us. So I'd like to go ahead and start with Commissioner Brown to my right, and we'll work our way left. Let's go ahead and hear what questions we have.
Sure. I guess maybe I'll start with Paul, staff. Just wanted to ask in response to what you just heard, which sounds like really not a opposition to the intent, but some of the nuances of the definitions that could cause issues. I guess just wanted, first of all, to hear your thoughts on that and whether it seems like there could be some modifications to take care of those issues.
So, and we have reviewed those text amendments with our counsel and reviewed those with him, who checked off on all of these. I'll speak to the first one first about the definition that we're trying to provide a bit of discretion here. We don't want that a facility that tells us that, oh, we're just dealing with the impacts of alcoholism, or we're just dealing with the impacts of drug abuse. Because in practice, these things are connected. Like there's a lot of sort of co-conditions, you know, that there's items, often like someone who has a substance abuse issue may have a mental health issue too, and that may be caused by this or maybe caused by that. I think they may be caused by one another, right? It's like the mental health condition may lead someone down towards a substance abuse issue, and vice versa. What we're trying to do is we're trying to regulate those facilities that, and we use kind of both the state licensing here, and then we'll use how people will be actually admitted. If there's sort of a facility that admits people with addiction issues, then we want to get at those, even if they treat other conditions too. And I think the challenge of a too narrow definition is that we'll have people tell us that, oh, we're not dealing with alcoholism, we're just dealing with the impacts of alcoholism on these people. So that's why we worded it the way we did. But we're more than happy to look at this with the attorney again to make sure that we're wording this in a way that's correct. The second item, alcoholism, we think from a land use perspective, these are similar. The impacts are by and large similar. They're sort of group facilities where people live that have substance abuse issues, like be it alcoholism or drug issues, and that come to seek treatment. We think from a zoning standpoint, those are close enough that we can group them under one definition. We're not saying here that each facility like treats both. We're saying that this definition applies to both facilities that treat drug abuse issues and facilities that treat alcohol abuse issues.
So, I mean, the intent is and or, correct?
Right. Yeah.
Okay. I did want to ask, I guess the ordinance itself, sorry, this is still for Paul. This proposal is coming out of just recognizing a gap in the ordinance that we needed to address, or is it also because there's a demand, there's people coming forward that are looking to establish these kind of uses?
Yeah, we had inquiries and then reviewed our code and found the gaps in our code. And then the city council issued a moratorium pretty much to allow us to fix those gaps.
And then I think my last question for you is just curious about, I know you guys have done research in other areas that have similar ordinances. What's kind of the typical size or number of occupants that these types of uses typically have? And, have you seen, I guess, limits on number of residents or number of units or anything like that?
So facilities can be very small. So almost like a personal care home type situation where you have someone living there and then do a live-in treatment. And they can be large facilities up to, several dozen people, 100 people too, that also exists. We reviewed the option to set specific limits or set specific distance conditions also with our legal counsel, who advised against it because of the protected status of the residents.
So ultimately, it's more of a function of the form and use regulations that go to the corresponding district rather than there being any specific limits to number of occupants.
And in those districts where a special land use permit would be issued, this could be a legitimate consideration based on impacts that are typical of uses. Depending on impacts on neighboring properties, on impacts on infrastructure, there could be, as part of the special land use permit, it's appropriate to set caps on the number of occupants or usage restrictions. That's certainly part of the special land use permit process.
All right, thanks, Paul. I'll defer to others.
All right, Paul, more questions. So to clarify, this is just for overnight and not like the people who are speaking, their facilities are not overnight, right?
Yes, so outpatient would not be regulated under this.
Yeah. That's all.
I don't have a question. I just have a comment. I would like to suggest when you review the proposed regulation, like the definition of it. I think the point that Commissioner Brown was getting to as well is like, it almost feels like it needs to be 2 bullets or just to clarify that. I think that would help a lot, just making some clarity. It feels like 2 bullets, basically. Thank you.
Commissioner Harris.
All right, just a couple of questions. So that was good answer on the limit of not limiting the number of residents in the treatment facilities. My other question would be, could you remind me, Paul, you said it was compared to, what was it, short-term or transitional housing regulations for how long the stay could be? What is the limitations on how long a resident could stay in a program like this?
This wouldn't set any standards. So
Okay,
we generally consider short-term up to 30 days and long-term anything over that,
okay,
but this could do both.
okay, great. My next question is, can you talk to me about the multifamily residential? And I'm just trying to wrap my head around how that could work in a situation like that. Could someone rent out an individual apartment and then as an individual, call it 3 people, recovering from drug addiction next to a neighbor who's got 2 6-month-olds? Like, can you walk me through what situations like that would be possible?
So a 2-part answer. So if you think of like a typical, let's say, garden apartment complex, in most instances, the property management would have no interest in having something like this on their property because their business is providing residential communities, and they'll likely find that this is not sort of suitable for what they're trying to do. And that's the second part is like that there would be a special land use permit process for something like this. And we would certainly look at it closely, like if it's just a specific unit in a building, I would have questions about that if that was proposed, but I don't know of facilities that are operating like that, at least legally. We have sort of police department response from time to time to issues like that in apartment complexes where there may be something like this going on, but it's generally without the knowledge of the property owner, and it's generally without proper licensing. So
Okay.
yeah.
Okay, that helps. Is this something then, I'm trying to imagine the different scenarios that could happen. So let's say we had on Peachtree Industrial, one of the apartments, could they lease out a building? They'd have to then go through the SLUT process to lease out a portion of the building that could be converted to a drug and alcohol rehabilitation center. Is that something that then would be permittable? And that would be the process?
Yeah, I guess it could be done. People can ask sort of for, people can ask for anything pretty much. Like I have a hard time seeing that this would be something that would be desirable by the apartment community. And I think from a treatment standpoint, I think it may not be desirable for the users also to provide something like, I mean, we would have to look at it from a special land use permit, what happens with shared amenities or like what happens with the specific entrance, and we would look at that as part of that process.
Okay.
So theoretically, people always can ask for anything, and then we would have to see how we would do that in a way that's
Okay.
that's
So
safe
then
for everybody.
I think my follow-up question to that, hearing the answers about the multifamily residentials, why do we have it as a used location, given that it's such an undesirable thing for either existing apartments or would be something that would be difficult to make happen? Why are we keeping multifamily residential in that mix?
So also a two-part answer. So we don't just have like those large garden apartment complexes with 30 buildings. We have a smaller multifamily properties too that consist of a single building that could credibly be a good location for something like this. When we're doing a process like this, if you're making a special land use permit, we're not saying that every single property that's zoned this is the right property for something like this, but we think that some of those could be.
Okay.
And then the second part to the answer is that we base this on existing zoning requirements that we have. There is sort of a universe, where we would step back and look at all these kind of group living facilities, but it's not what we did here. Like on the advice of our council, we selected sort of the closest related from a land use standpoint category that we have, and then modeled it after this. And so we didn't want to take something out of this one that deals with a protected class. Yeah.
Okay. And then my last question is going to be, per the last person who spoke, I wrote down Andrew Merker, but I feel like that last name might be wrong. Paul, question, if we were to remove alcoholism from the regulation that we're proposing from the code, would that mean that those treatment centers would operate without restriction, or that they could not operate at all?
So the challenge with this is then our code says if something is not in the use table, it's not a permitted use anywhere. Like, so we would strongly suggest like to keep it included
Okay,
as part of this to make sure that we have it somewhere in the code.
okay. All right, thank you so much.
Commissioner Coyle?
Okay, so following up on Erica's last question, the language that's in the chart says drug rehabilitation center or other facility for treatment of drug dependency. So that doesn't even include alcohol. So was that intentional?
Yes, it was like it's the existing term that we use in the code. So it's established in the code already. So we kept that term because it is established, and then we included a definition that describes what is regulated by that use category.
Okay. And then my other question is that if you struck the language that Mr. Katz suggested striking, the with diseases related to, does that in any way limit treatment?
So the fear I would have, and I would want to talk to our attorney about this too. The fear I would have is that we regulate it so narrow that that we'll have a hard time identifying specifically the facilities based on something that I've mentioned it before, that someone might say that no, we're not dealing with a drug dependency, we're really dealing with the conditions that stem from drug dependency. So we tend to write these regulations as a bit of a catch-all to address those cases too.
So maybe moving or conditions and diseases related to the end of that phrase would broaden it a bit. Just a thought.
Commissioner Gordon?
I just had one question about the second text that we were going over. This gentleman suggested that the text should be reworded, but I was wondering if he had any suggestions for that.
Actually, I do, and I would like to say that I did contact your attorney, but he did not return my call. I did offer to meet with him regarding this, and it's disappointing that I didn't get a call back. I've been in Dunwoody since 1973, and I was hoping that I would have gotten a better response. Let me tell you what the difficulty is here. Let's say you have a person who has in the past been a substance abuse and he's suffering from depression. And you have somebody who's suffering from depression unrelated to any kind of alcoholism or drug abuse. Then a mental health facility, what you're saying by this regulation, you can treat that kind of person who's never had any connection whatsoever because his depression is not a disease related to substance alcoholism or substance abuse, whereas the other person in this mental health facility you can't treat. And so when you say the impacts of substance abuse, virtually every person with any kind of mental illness in this country is going to have a risk, whether they've had previous or a history, be at risk for substance abuse. I think what you're after here is to say, hey, if you're treating this, you're a drug rehabilitation center, okay, you're going to have to get a special use permit. And that seems reasonable to me. Providing special use is not unduly restrictive, but to say diseases related to, then you're putting it in the hands of your employees to make these decisions. So if you take out diseases related to, then I think that your employees are implementing this can still say, look, if you are dealing with a situation where virtually everything you're doing is drug or substance abuse or alcoholism, then you're going to have to get that special use. But if you're a mental health treatment center, like my clients, then the fact that there is a risk or that that substance abuse might in some form or fashion be related to a mental health illness. So long as mental illness is what's being treated, and it's not predominantly being treated for drug dependency. For example, my clients, you won't find any kind of 12-step meeting at their location. You won't find any counseling sessions at their location where they sit around and talk about their drug dependency. What you find is treatment for things like depression, anxiety. But if you remove the with diseases related to and just put dealing with alcoholism and or drug addiction, then I think at that level you have to trust your employees to know what facilities really are hardcore drug rehabilitation, and which ones aren't, which ones are doing something different, which may have an incidental impact with substance abuse. And so my suggestion would be simply removing diseases related to. If you remove those three words, you're not sweeping so broadly. I appreciate the opportunity to answer your questions.
Thank you.
Commissioner Gordon, anything further?
I was wondering if the other gentleman that spoke had any suggested text revisions also. Sure, or yeah,
Yeah,
what would go into the
Well-
regulation?
ultimately, let me get back to it, sorry. I didn't think I would have to talk twice, I apologize. Maybe I left that page back there. Hmm. Paul, do you have it?
Commissioner Gordon, if there is no
Yeah.
immediate ability to
Sorry.
add to this, can we defer this perhaps?
Yes,
Okay.
yeah, and I
If-
didn't,
If you have immediate thoughts, we'll be happy to hear them, but if there's a process that we have to undergo, we may go ahead and push forward.
Okay, yeah, so the immediate thought would be to take away what Stephen was referring to. And the and or lodging component of an overnight stay. It needs to read where it would require medical attention overnight stay, because you're classifying anybody's facility that is treating in an OI, a nursing home that has alcoholics, that they can't stay there anymore, that you're classifying a group home that has an alcoholic or a homeless shelter that has a drug addict in it, and that they wouldn't be able to stay in those components. Because without the medical component, it's not a treatment center, it's just a house.
that clears, that's what I was asking.
Yeah.
Thank you for that clarification.
Paul, may I ask, and this is probably treading some ground we've already treaded, but I want to talk through this with you. Just so I understand kind of the procedural posture. Not necessarily tonight, but we need to act on this. This is a gap in the code that's going to create issues if we do not act to push something forward before the moratorium ends, correct?
Correct.
So this needs our attention. We can't We can't just say, no, we're not going to do anything. Something's going to have to be done. We just
Correct, yeah.
need to define what that is. Okay. Speaking regarding Paul again, speaking regarding the drug versus alcohol refinements there. With regard to specifically allowing a rehabilitation center for the treatment of dependency, drug versus alcohol versus otherwise, have we put the question to our council that the inclusion or omission of alcohol would obviate the ability of somebody to open such a treatment facility? Have we put that to council, that question?
Could you rephrase? I don't.
Does the omission as Mr. Merker noted, does the addition or omission of the term alcohol and its status that is somewhat different than drug, at least in the eyes of state law, does that materially affect how this current text is applied and interpreted in the context of the permitting process?
So we have it worded as like related to alcoholism or drug addiction. So this is like, it can be either one. Like if it's just drug addiction, it would fall under this. If it's just alcoholism, it would fall under this. If it's both, it would fall under this too. You know, it's not that not both need to be present at the same time. So I don't think it would.
Okay. All right. Now, having heard the other arguments from Mr. Katz with regard to diseases related to versus the actual diseases themselves, or perhaps the diseases themselves plus immediately related conditions, that specific issue has not been considered by our council at this point, correct?
This has, so what we've done, we've sent the entire thing, the entire text amendment to the council that includes the definition, that includes the use standards and the use table. We had some feedback on this. We made changes based on that, send it back, and then it got reviewed again. So he's reviewed the definition as is and okayed it more or less. Okay.
All right. Thank you. All right, council, at this point, commissioners rather, we're going to need to figure out what we want to do tonight. The way I see it, I'm not.
Mr. Chairman, and
Yes,
like Rachel just mentioned,
Yes.
like we haven't posed those questions specifically to him. You know, we've sent the sort of point of correction, like we've sent the entirety of the definition to him
Okay.
twice, and we received no comments on it back.
Okay. So, among our options tonight, I'm not sure that denial is an option. Well, it always is, but I'm not sure that's the right option. Deferral might be an option, or we could approve this as written or as modified. But I think ultimately, and what I would ask you all to do as we push forward with crafting a motion that we can hopefully all agree on, or the majority of us can agree on, is let's get this language looked at. In particular, the language that Mr. Katz rose to our attention, I believe that bears further scrutiny, in my opinion. And I would certainly support a motion that allowed us to review that or suggest it or condition it in our motion. So that's my 2 cents for this group. So with that said, is there anybody that has thoughts about how they want to approach this motion wise?
Yeah, I guess maybe just a clarification. Can we basically approve it and send it to council, but with the recommendation to staff that they have it further looked at, or look at the striking of that one little clause that Mr. Katz suggested? So I think that's worth consideration. Or do we essentially need to, would that require deferment, or could that be an approval with kind of a condition for staff to kind of look at it further?
Yeah, and I think Richard obviously has something to say on that matter. So.
Yeah, you could condition it on the language. We're gonna take it both the language for both of them to the attorneys anyway to get it settled. So you can make it as part of your motion.
So ultimately, I think this is, do we want to see this again? Or do we want to give clear directions that are likely to resolve this in a legally sufficient way and not see it again? And that's certainly going to be up to our.
So is our is the question for us, should this use be approved or should it be approved as written?
Yes. I'm going to be evasive, but I think ultimately what we all have to agree on if we're going to push something forward is, do we like it as written? Do we want to modify it? Do we want to modify it and say, take a look at this and make sure it passes muster? You know, we're flexible enough. We can do whatever we want, but ultimately I think the issue is, as Commissioner Brown pointed out, do we want to see this again? Do we want another bite at this, or do we believe we can give sufficient guidance before it actually hits council to allow a well-reasoned argument to be made?
Could I make, so my thoughts are that I think that we're in a little bit of a time bind here, and holding it up 1 month, I think would give council less of an ability to give it a little more time if they needed it after they saw it. My preference would be to move it forward with some of the recommendations we've seen tonight. I would also love to move it forward to have them look at the multifamily residential, because we include all the multifamily residential. And I'm not sure, based on what we've seen today, that, or what we've heard today rather, that necessarily every single one needs to be in that category. But but I don't know if we have the time to dig into that. I would just love to see that looked at maybe a little bit more. So, and no one has to agree with me. We wouldn't have to add that on as a condition, but it's something that I certainly, when we wrap up and give feedback to city council, I would love for them to look into that multifamily residential. Do we have to have every category in there? Or would there be a way to simplify it so that we're limiting maybe a little more tightly areas that would be more considerate for that location or for those types of operations? So I think we push forward.
Well, then commissioners, does somebody want to posit a motion, and we'll see what sticks?
So can I just want to make a comment about what Erica just said. It seems to me that if there is an application for a special land use permit for a multifamily area, her concerns are addressed through the application process and potentially through the owners of the property, whether or not they're going to allow it. That was just my thought on that.
Can I just make one additional comment before we get a motion? I do think, I was just thinking about your comment, Mr. O'Brien, about the first line, right, of the definition where it does only say drug dependency, and then we further define it as alcoholism. I think if we're going to make a motion to further review, I would have them look at that, because the part where it's not defined that way in the state of Georgia, I think that piece does concern me. So just to have them verify if we need to clarify it or change that. Because it does seem like it's in conflict with each other when it says drug dependency and then goes on to say drug and alcoholism.
Okay.
So,
Well, I mean, we've got several items that I think are of importance, and so does somebody want to put forth a motion? We'll see what survives. Maybe we have to go through this a couple of times to get it right, but is there a motion on the floor?
Can we approve the concept? And I mean, because I don't think we have the ability to rewrite the language appropriately here. So can we approve the code in concept with a recommendation for council to review the language to make sure it's inclusive of alcoholism and meets the goal?
Yeah, you can either you can recommend approval as written. You can make changes as part of your motion. You can provide sort of direction for the staff and for the council, or like recommendations for the council as part of your motion too. So you have those options.
Okay, I'm going to take a stab at this.
Great.
I'm going to make a motion to approve the text amendments, with the exception that I would like staff to re-review the definition and the title of the use. Trying not to make this too complicated. I would like them to review potentially removing the with diseases related to part of the definition. And I would like them to review the potential for the title of the definition, including both drug and alcohol.
Good. Okay, so Commissioner Brown, I'm going to restate that to you and then we'll seek a second. I heard you make a motion to approve as written with the additional exceptions of reviewing the definition and title to include potentially removing the language that Mr. Katz brought to our attention, diseases relating to that language, as well as the potential for amending the title to properly include alcohol to interact with the state definitions as well as the intent of what we're attempting to accomplish here.
Yes, I
That's-
think you
is that a
captured it
fair
correctly.
restatement?
Yes.
Okay, hearing a motion, do we hear a second?
So sort of, I mean, yes,
Well,
but the title, so the title of the section, will that be included in the tables as well? So if the title of the section is amended to include alcohol, will that be included in the tables also?
Yeah, we would
Well-
make sure that once we have established, define the use, that it's consistent throughout the code.
And right now, the title is kind of not consistent with the text of the amendment. Title does not include alcohol, and so I think that trying to resolve that is aspirational, and if it leaves here with a direction to look at that, I think that I'm stating the issue that you have there, correct?
Right, yeah.
Okay, so we've heard a motion. Is there a second on that motion?
Second.
All right, Commissioner Harris seconds it. We've got a motion and a second. At this time, anybody have thoughts, debate, or additional elements that we want to discuss relating to this? Hearing none, we'll go ahead and move forward with voting. All in favor of approving the motion, raise your hand. All opposed, like sign. All right, the motion carries 6-0. Thank you very much. All right, moving forward, item 2. Review and consideration of a text amendment to create regulations for medical cannabis dispensaries.
So this the second text amendment for today. And this one is necessitated by changes in the state law that go back several years now. The most sort of fundamental act that was adopted by the state is Georgia's Hope Act of 2019 that allowed for the production, distribution, and dispensing of low THC oil to registered patients. It took several more years for the state to establish a licensing process. There were lawsuits and so forth around it, but it's come now to where it's sort of ready for implementation. The first dispensaries have opened as of recently. It establishes the state law established 2 pathways to legally dispense medical cannabis. With one of them we're dealing tonight, which is the first one here. Established the Georgia Access to Medical Cannabis Commission that approved a total of 5 dedicated or 5 companies, issued licenses to 5 companies to produce, distribute, and dispense. And each one of those will have, or like it distributed, like ultimately it will distribute 6 licenses. That's correct. 6 licenses with 5 dispensaries each, and it has issued the first 2 licenses. So what we currently have is 2 licenses that can do 5 dispensaries each with a total of 10, and eventually it'll be a total of 30 for the entire state of Georgia. There's a second pathway that is not fleshed out yet. That's through the State Board of Pharmacy, and this is the entity that regulates pharmacies, something like CVS or independent pharmacies. There's still no clear timeline on the rules through that and what that means. For dispensing, the state law has provided use standards here that will have to carry over, will have to be at least as protective as the state is, which include a minimum distance of 1,000 feet from public or private schools, early care education programs, and places of worship. So those are in the state law, and you'll see that we propose to carry this over into our municipal regulation as well. The state is clear that municipalities can use their zoning powers in addition, so it didn't preempt the issue. It specifically states that we can use our zoning powers to regulate these uses based on the local needs, as long as we're at least as strict sort of as the state is. And we have the first of those locations opened statewide. The first ones are open in Marietta, Macon, and Pooler. And I went to the location in Marietta to see for myself. And I'll show you all an image of that. The second company, so this is all one company called True Leaf that operates these first facilities. Second company called Botanical Sciences has a license, but has not opened any locations yet. Just brief feedback on what is before you all tonight. This is not recreational cannabis, this is medical cannabis, and it's a very low percentage, a low dosage type of cannabis. It's only legal, Georgia only legalized low THC oil with no more than 5% THC content. And for comparison, typical like recreational marijuana products may have 19% and more of THC content. So this is, from a dosage standpoint, it's a less potent medication than you can get in other states. Georgia requires a medical card that can be given only after doctor's consultation, registration with the state, and only for 17 specific medical conditions. So it's only if you meet one of those medical conditions can you get a card like this. What this means, like it's a very strict medical cannabis law in Georgia. It's one of the strictest in the country. That will likely lead, to lower dosage products and overall reduce the impact both, you can think of it twofold. It'll, on the one hand, reduce the externalities of these facilities because what they're selling is really not like a very strong product. And it'll also likely have less impact on the illegal market in the state because these products aren't as attractive, I think, for recreational users. And this is sort of like a map that shows in dark green where nationwide medical and recreational cannabis is legal, and then in light green where medical cannabis is legal only. And this provider did not even classify Georgia as a state that allows for that due to the low dosage of the THC products that will be sold in Georgia. As part of this, we've reached out to our neighbor to the south that has where medical cannabis is legal since 2014, just to see what the experiences are. And we looked sort of on Google Maps, on Google Street View, we looked at the type of facilities, the type of locations these facilities tend to go to identify the land use impact. They tend to go into relatively small retail spaces between 2,000 and 5,000 square feet. They both will go into inline retail suites. So let's say you have a strip shopping center, they will go into an interior suite there. They will also go into freestanding retail or restaurant buildings. We talked with some of the planners at these communities, and they found that the traffic impact is really not different from other retail uses or pharmacies, and no one would report nuisances that go with these uses. And now you can see for yourself in Marietta, there's a first facility that opened up about a month ago. It's through True Leave, and you can see it here on the right hand side. They went into a shopping center on Cobb Parkway, and they're operating sort of a small suite there. And this is how it looks. So really not tremendously noticeable. The one thing that they have is they typically have the windows blocked, which is only possible in some of our districts, not possible in other districts, for presumed privacy reasons. Overall, from a regulatory standpoint, so Georgia, or like state of Georgia, has decided that this is sort of a valuable medical resource to residents. Right now, we only 30 locations will be approved statewide. So we presume that if we do very burdensome regulations, that instead of coming to Dunwoody, that these facilities will just go to a location that has less burdensome regulations due to the low amount of approved facilities. Overall, we're not anticipating negative externalities because they're not reported elsewhere, and these are medical facilities, where you need a prescription, and they're heavily regulated. We thought of whether to do it as a permitted use or a special use, or like a special land use permit. And we're recommending to do it as a permitted use, because really from the concept of a special land use permit, the idea behind it is that you limit externalities, that you limit, let's say, the operating hours, that you limit, let's say, the size, the arrangement. But here we really have operators that go into existing retail spaces. So it doesn't capture as well what's going on. And yeah, the impacts aren't tremendously different from typical retail uses. What we're proposing today is to make it a permitted use in like all of our retail districts pretty much. And this you'll find this is the same, it mirrors like our other retail uses. Like we have a zoning ordinance that has a really broad other retail uses description, and it mirrors this. So it can go where typical retail uses can go under this. We're carrying over the state distance requirements. I have for comparison, I have here what it is for liquor stores, and this tends to be slightly higher. It's different, but it's slightly higher than what we typically have for package stores. What we're proposing to do in addition to this is to have sort of an anti-clustering regulation here. Like we're proposing to have a 2-mile radius around facilities. So what this does is that if one location operates on a corner, then a second location can't operate sort of on the other side of the intersection or in close proximity. This is sort of a careful, conservative approach to this to let us see how it develops. And then we're proposing language that prevents consumption on the premises so that people can purchase the THC oil, but they can't use it on the premises. And that's sort of a quality of life issue. So this we sent over with a bit of descriptions because I understand that this map is somewhat hard to read. I can pull it up and zoom in a little bit more, but it's part of your package. What this does is it shows like we considered a different number of radius for the anti-clustering requirement. We looked at like a 1-mile radius, a 1.5 miles, a 2-mile radius. And what this map pretty much shows is that you can have up to 2 locations in perimeter center. you can have one location in Georgetown. You can have one location in along sort of Peachtree Industrial, and one location along Winters Chapel, based on the distancing requirement. But in each of those little neighborhood centers, you wouldn't be able to do a second location. So that's what the 2 mile requirement accomplishes. With this, I would like to conclude the staff presentation, and I'm ready for questions.
Okay, thank you. Again, before we go with commissioner questions, want to give the opportunity for anybody present to speak in favor? Seeing nobody, anybody speaking against? All right, at this time, we'll then start to my left. Commissioner Gordon, if you have questions, please proceed.
So I can't really see it on here in front of me, but I was looking at it earlier and it seemed like only 2 of the proposed locations satisfied all the requirements, like being far enough away from schools and churches and all that stuff.
And I can go into it. Let's see.
It seems like only the one on the northeast corner of the city and the southwest corner of the city would really work, unless I'm misunderstanding.
The way to read is like all the red dots that we have here that have the radiuses around here do work. And sort of the way to think about this map is that all the dark gray areas meet the general zoning district. So they're in a zoning district that allows for this use. So everything in dark gray meets the general requirement to operate a facility. Then anything that's outlined in green is not impacted by any distance requirements, because there are no places of worship or there are no daycare facilities close by. Anything that's sort of outlined in red, like this location over here, because you have the Montessori school over here, that is a daycare center that gets this buffer around it, which is the dark blue area. So all the parcels that are in close proximity to that would not be eligible based on that state distancing requirement. So we have for the sort of red dots that show the locations that have the distances around there, all of those are eligible properties that would allow for a facility. We have areas up here, like in the Dunwoody village, where based on the number of churches or based on the daycare facilities and those type of things, but there's no eligible, even though it's zone commercial and it allows for the use in the use table. Due to all these facilities that have the increased distance standards, no parcel in Dunwoody village would be eligible. And this is just because of state law. This is, even if we wanted, we couldn't get around that.
Yeah, thank you.
How is your map that showed the states in the United States that state of marijuana legalization in the US? Georgia's low THC oil is called CBD oil in other states. What is the CBD store in Dunwoody Village? What is that? One of what we're talking about here? No.
So it's that there is no, because under federal law, it's a controlled substance. So there is no overarching federal, there's no overall federal classification scheme for these things, because it's overall under federal law, it's still considered a controlled substance. So what generally is sold here as CBD is not considered a it's not the the active ingredient in cannabis. It's another ingredient, but it's not the one that gives you the high, so to say. So this really is the typical CBD store sells you something that has no THC, so does not have the active ingredient. What some states have is they have a specific cutoff, which Georgia does not. But like some states have a specific cutoff, or some private providers that collect the information have a cutoff that, let's say, everything under 10% of THC content, and THC being the active ingredient, that everything under 10% is, let's say, so diluted that it's not counted as sort of proper THC cannabis. So that's what's going on in that map. It's like that provider, Statista, uses a classification scheme that that would not even classify the Georgia program as a full-fledged medical cannabis program.
But that location in Dunwoody Village is not considered any part of what we're talking about here.
No, they cannot sell products with any THC content.
So probably a Captain Obvious question, but as Georgia amends what the medical cannabis law would be, or regulations would be, would those regulations automatically grow with our code? For example, I don't think our code, we cite the numbers like the 0.5. So I'm assuming as Georgia amends things, so this code would automatically grow with that.
Correct, yeah. So if the state of Georgia, we are defining, we're just citing medical cannabis as defined in the state law. So if the state law changes, then our code would automatically use the new definition.
Okay, and then my follow-up question to that would be, if Georgia were to legalize marijuana, would this be considered the same type of store where legalized marijuana could be sold as well as medical marijuana, or would this be limited to medical marijuana?
So that may well be that the stores want to do that. The same stores want to sell recreational cannabis as well. Our code states kind of like that it's a license for the sale and distribution of medical cannabis products. So that it would not automatically.
Okay.
That it would not automatically adopt. So it's just right now, it's just for this specific product sort of that's envisioned by the state of Georgia, that is approved by this Georgia Medical Cannabis Commission, and that's licensed through that. If at a later point the state decides to allow recreational cannabis, then we would have to come back with something that allows that.
Okay, thank you. And so my last two follow-ups is in regarding schools or daycare centers, in the right-hand corner, the southeast corner, there's a red dot on that. There's a gas station down there, and also a commercial district. There's also Corners Outreach down there, and that is a after-school childcare facility. So would that be still allowed in that location, or would that be, because it is a childcare facility, would that then no longer be allowed in that area?
So it depends. We would have to see. So what it means is, if it's not captured by our map, is that it's probably not licensed as exactly this. It's probably licensed as something else. And then they also do after school program. What we would have to do is like look at the definition for the state.
Okay.
And then I would presume, but I don't want to say for sure because I haven't looked at it. I don't know exactly what they do. I would presume if it is something that is a licensed childcare facility, that the location down there would be struck as well.
Okay, yeah, that I would look into that area because they do 5 day a week after school, elementary and middle school after school program, and they also do summer school programs there. So that would be something to take a peek at. My last question is, where do we allow fully covered windows? Because that's something that I think in the city, I wouldn't be comfortable. I think it sets up a bit of a seedy atmosphere when we start doing fully covered windows. So I would, while I'm in favor of doing this, I'm not in favor of what I saw in that photo, which are fully covered windows. So how can we not allow that?
So we have right now, so we have the two code requirements that go to that. We have in some districts, we have specific transparency requirements. So where there needs to be specific amount of area sort of needs to be see-through pretty much, and that's in perimeter center and the Dunwoody Village. We have a second requirement that you cannot cover windows with signage
Right.
by more than 30%, I think. And that's for each window pane. So what these places tend to do is they tend to have blinds on the inside also that are in practice permanently closed. We can certainly make this a use standard where we sort of address the window treatment of these facilities. So what it may do is, and I've reached out to, actually, I had the same thought because we have this in some of our districts. Already we have these transparency requirements. I've reached out to one of the companies that I was in contact with and asked if that would be for them like a insurmountable concern based on privacy or whatnot, that they don't want people to look in there, and I haven't received a clear response. So I'm not sure what exactly it would do, if it would be sort of a reason for companies not to come.
Yeah, I mean, just, and this isn't meant to be, oh gosh, what's the word for it? Creating disagreement, but I mean, women go to pharmacies and buy Plan B, and that's not very comfortable. I would say that in a situation like this, it's a medical use. And I think we're a pretty understanding group, and this is something where I'm not for the covered. So I would like to see a way to make sure that we're not allowing a, blanket out type of situations. I'm not sure how we would do that, or if that's something we would make clear now, Paul, like how.
No, I would propose two things to the commission if that's of interest. One is like, we could let the existing regulations stand, so it would be classified just like other uses where they could do it in the same districts where retail users can do these types of things, but they cannot do it in the districts that don't allow for it. So this wouldn't give them specific, like as written, it wouldn't allow the facilities to do this in perimeter center and Dunwoody Village, but it would allow it in commercial districts outside of perimeter center, for instance. The second one is that we would make it a use standard, that let's say we could say that there shall not be a permanent window treatment that would limit view into the store. We could make it a use standard like that hypothetically.
Okay, all right. I will noodle on that. Thank you so much.
Mr. Edmondson.
Yeah, I just want to follow up to Erica's comments because I've been noodling on that myself. I think the one thing I was thinking about is I'm not opposed to having a use standard that has a percentage of transparency. I was thinking about the security piece of it, of if somebody goes in and is that person then at risk or something. Like, I'm thinking about it from a security perspective of product being out or somebody seeing somebody get product and then leaving the store because we're not going to permit them to use it there. Does that then cause a security thing? Is that maybe somewhat of a protection.
It's a Schedule I federally
Yeah.
prohibited substance. And if their federal law enforcement is properly interested in an individual, there could be issues that came from that. I believe that medical purposes should be able to be private. So that's my 2 cents.
Yeah,
This is an illegal substance on a federal basis.
right. I'm just talking about that, like, I mean, I would see somebody going in, getting their medicine, coming out, and somebody having seen them through the window and waiting for them at their car and trying to.
Interesting.
their substance.
Yeah, at this level with the oil. I mean, but on that note, you go to Walgreens and you pick up your opioid prescriptions.
But they don't know
And-
what you're getting. Yeah,
And I can sort of answer like the layout of the Marietta store, and other places may have a different layout or may have the same layout, but
yeah,
the layout there is that you have a lobby area where people check, or the attendant checks for your medical card. Pretty much you have a separate room in the back that is for consultations where the product is stored. So those are not visible. Then out front, it really looks like a medical office lobby
mhm.
kind of a thing, but there's a desk there where you check in properly, and that's the arrangement of the Marietta store.
Okay, that's helpful. Okay. I think the other question I had was around treatment facilities. So if we're putting a minimum distance from schools, early care, education, places of worship, did you guys consider proximity to treatment facilities? You know,
That's the we thought about it. Like, I mean, there is an argument for proximity between those two. Like where there's a medical facility, and then you have in close proximity, you have a pharmacy, let's say, or like you have so you have the place that gives you the prescription, and then you have the place where you can pick up sort of the medication close by. That's fairly common. So we didn't think that it would warrant a distance requirement.
that's it.
Commissioner Shin. Commissioner Brown.
Yeah, just I may be in the minority here, but I guess I'm curious why we feel the need to go beyond and do the 2 mile thing. Because you said in the memo that there's really not a nuisance involved with this type of use. And in addition to that, in your PowerPoint, you talked about the overly strict regulations can cause some spillover effects and things like that. I agree, we don't want necessarily these uses to be clustered together, like on the same property or in the same shopping center, but you know, the 2 mile thing, I know you had the dot on the map in perimeter center that was kind of at the far southwestern edge of the city. And yeah, you could conceivably have 2 within the perimeter center area, but say you had one in perimeter mall, that would pretty much kill the entire area for a second one. And that's pretty major urban center. So just wondering if maybe the 2 mile thing is, you know, like we're eliminating a lot of places already with 1,000 feet restrictions and stuff like that. And just wondering if we might consider something closer to liquor stores where we're spacing them out 600 feet instead of 2 miles, so that we're not getting clusters, but we're still allowing a little more flexibility. I guess maybe that's not a question so much as just a thought or comment. But I do want to ask about maybe the definition. And, you know, we've got a facility that is for sale and distribution of medical cannabis products as defined in the Georgia Code. I'm wondering should we add low THC to that definition, or is that pretty much assumed under the Georgia Code? Just trying to protect ourselves in the circumstance that you know, regulations change. You know, we want to protect ourselves from all of a sudden a flood of new uses potentially, not necessarily a flood, but getting a lot of new applications where because of the regulation that we set now, maybe we're open to more things in the future as the Georgia code changes. So would it make sense to add low THC to that definition, or is that kind of assumed by saying as defined in the Georgia code?
So it provides, right now, the way it's written, it provides the flexibility. If the Georgia code changes in here, then we would, like the definition of medical cannabis products changes in there, let's say they go from 5 to 10%, then our code is flexible enough to just carry that over. So if we have a facility established that sells what's currently legal, there's the challenge if we don't follow the state requirements, that we have this facility opened up, let's say in 2023, and then in 2025, Georgia goes from 5 to 10%, and then our code only allows the 5%, which would pretty much put that facility into a range. So it's probably the more elegant solution is to stick with the state law, and kind of if we have specific fears around it, to go with typical kind of like zoning standards. Yeah.
Okay. I see your point there. I think following the state makes sense. And as long as we're saying medical and not opening ourselves up to recreational, I think that more or less covers it. I think that's all the questions, but I would say that I think I'm with what Thomas said earlier about the window treatments. I just kind of hesitate to getting into regulating window treatments for anything medical related, just for discretion and privacy purposes. That's all for me.
Thank you. I'm about to call for a motion, but before I do, the culture is changing with regard to medical marijuana, and I want to put on the record and posit to everybody that I think it's wrong to treat medical marijuana in this context as illicit. And I'll cite as by way of example, we're putting it up here next to alcohol sales when looking at the distances. It's not. The reason this law came about was in no small part due to lobbying on behalf of a minor child who low THC oil was the only thing that could deal with her intractable seizures. So I don't like the idea that we're commingling this with something that's a vice. It's not, this is not a vice. It's not defined as a vice. It's not. So to echo your sentiments about the 2 miles, I agree. I don't think there should be the 2 mile restriction. In fact, I think competition's good. Maybe don't want them at every street corner. So maybe there is a distance that is appropriate, but I also don't think that we would regulate Walgreens from opening up a block down the street from CVS. Exactly. And so I would urge us to look at that. This is in a very true sense medicine. It's being prescribed by physicians who believe that this is appropriate. Federal government hasn't caught up yet, but we're given a solution here. It's medicine. I'd like it to make it available. I'd love to make it a competitive situation whereby these folks are going to have to fight for the business of properly credentialed people. And I think having it here in Dunwoody would be good, not only for Dunwoody citizens, but for people in the general area. And so I would urge everybody to think of it in that context. And so with that in mind, what's your pleasure, Commissioner?
Well, can I ask you a follow-up question to that? Why is Walgreens not allowed to sell it? Because it's interesting to me that we are considering something, that is pharmaceutical. I have a couple of thoughts or questions on here. Like, if it is pharmaceutical, why isn't Walgreens and CVS selling it? Like, why is it in all these small kind of independent run businesses? And I think as a follow-up, and so maybe help me understand this next part, Paul, is now it is medical. Are we limiting this because as it grows and it goes beyond medical, then are we looking at just cannabis sale locations, not pharmacies, which I think is important to parse out here. Are we looking at just pharmacies, or are we looking at locations that would then be legal to just sell recreational marijuana?
So I'll answer your first question first. There's, because of the federal status, there's significant impact on businesses. So often businesses can't accept credit card payments that deal with this. People may not be able to do operate in the formal banking system. And so I think that's the challenge with the licensing for pharmacies too, where it's supposed to be done. It may not be maybe licensed or open for pharmacies in the future, because there is the second licensing process that the state is considering right now. The odds are that CVS will say no, thank you, until things change on the federal level. So for instance, the Marietta store did not accept credit cards because Visa and MasterCard won't process these types of payments. So that's why it's like smaller businesses, and often like more like single purpose businesses, even in other states.
And so probably not even covered by insurance then for the same reason, federal.
That I think that's true. There's some insurance that is sort of federal on the federal marketplace, or they get subsidies federally, and that will often not cover these types of treatments. That's correct. The second part, if this happens, like if let's say the pharmacies can sell this in the future, and then this CVS would consider selling this, then they would not be considered a medical cannabis dispensary under this, because it's not a license for the sale and distribution of medical cannabis products as defined in this section, but it is a pharmacy that can just sell this. So this is specifically for the facilities that are licensed as these medical cannabis dispensaries. So if in the future, hypothetically, CVS can sell opioids and medical cannabis, then that would just be allowed in our code. This would not be covered by this. If in the future recreational gets allowed, that would require a separate amendment, or in our code specifically, because we have this category of other retail sales. Like if it becomes legal to do so on the state level, it would probably be legal in Dunwoody, and we would have to, if we wanted to regulate it any different, we would have to, just like with this use, we would have to create regulations for it.
That's helpful. Thank you so much.
So what is the genesis of the 2-mile radius? Was that something suggested by attorneys, council, mayor?
No, I think it's a conservative approach to this because it's new. We don't exactly know what it is. We have a part of our population that is, very happy that this is happening, and we have a part of our population that is has concerns around, because cannabis use was just, even a few years ago, was considered just much more stigmatized than it is now. So this is an attempt to allow these in the city of Dunwoody for residents, but to limit the impacts. And if so, where we sort of pretty much cap the maximum number of facilities that there can be, that's what it's trying to do.
Hey, Paul, I have a question. In the perimeter center district, you're showing that some of that is actually residential area that's green.
Mhm.
And maybe it was just, maybe because it's mixed use but
Yeah.
that wouldn't be allowed for sale.
They're technically a mixed use district. So the we have in perimeter, we have a lot of OCR kind of zoning, which is like office, commercial, residential, which is like the old DeKalb mixed use zoning pretty much. So if hypothetically some of those residential like multifamily buildings would be redeveloped to do retail in the ground floor or something to that nature, then they could do they currently can do restaurants or soft goods stores. And then if this passes, they could also do a medical cannabis dispensary.
And you said there's the 3 locations now in Georgia, so there's 30 total that can be built. So that there's 27 as of now left that could go statewide. So
Correct, yeah.
even if we change that buffer, it's not like all 27 are gonna come to Dunwoody.
Yeah, presumably not. And this may change, like this is somewhat fluid. You know, there were proposals in the legislature to increase the number of providers. So I wouldn't believe that we'll have the cap of 30 into eternity. I would, if this rolls out and it's successful, I would presume that the final numbers will be higher.
This is just following up with some thoughts. Thomas, I completely agree with you that from the medical side, we want people to be able to access this. People who are suffering from cancer and receiving chemo treatment, you know, people who have severe joint pain. There's a lot, there is a place for this for sure. At the same time, my question is, because what I've seen on the West Coast was it roll from medical to recreational. And then you go to places like Boulder, and in the city of Boulder, you have about 300 dispensaries for recreational cannabis use, but it started as medical. And so all these single buildings, you know, and it's huge. I have a family relative who is in the drug rehabilitation program. Like he runs one. And one of the struggles that they have in California is the predominance of how some of these buildings have overtaken and so that's why I'm asking the questions, or I'm sorry, these companies have overtaken. And look, they make a lot of money, the recreational ones do. And that's what they're there for. I mean, they make a lot of money. So they're in business for that reason. So my questions in terms of like, would these medical dispensaries be able to roll into, be able to then automatically roll into areas where the marijuana would be legally sold? If that were the case, then I could see reason why we would want to limit how many, so that all of a sudden we're not dotting 2 or 3 dispensaries in a shopping center, or within 600 feet of each other, because I have seen cities where that exists. And I don't know if that's the culture that the city of Dunwoody wants to see. But that's what I'm trying to separate where things may go from what we're proposing now. And it's hard. I mean, Paul, that's why you see me struggling. Like 2 miles seems like a lot, but is that 2 miles?
I think Paul mentioned, like, if the law changes, that recreational is now legal, that this would have to get updated and come back in front of us. So at that time, we could change the distancing requirement so that existing facilities would have, or new facilities would have to follow that new under recreational use.
Right. So that's where if we look at this now, though, and so if we do something that's less limiting, how many could then be put in? And if you watched it roll over into recreational, where would that be? How many would that be? I think that's my question, is just what we're looking at today versus what we're looking at tomorrow, because this is a bit of a, you know, a fast moving train. When we look at it in terms of openness and acceptance of it. And so the question becomes, is within the city, what do we want to see? I'll be very honest, it's interesting because in the PCID area, like that seems like there is an area where that community would seem underserved from the pharmacy standpoint based on the regulations we offer. So it would be nice to be able, oh, well, no, we've got 1, 2 in the PCID. 1, I see 1 down in the far.
You can add another one in that green off of Meadow Lane, like where the Walmart is. They just aren't showing a dot.
Tom, what would you suggest for a change in distance?
Yeah, I think there is merit in having some distance, but I think 2 miles is excessive. Were I to propose a motion, I'd probably try and pick some sort of. Well, we've got concentric circles here, each at a 1 mile, 1.5 and 2 miles, right? And I think there would be a pretty material change if we looked at, say, making it, we got a 1/2 mile. That's arbitrary. There's no science to that, but I think part of this culture shift and part of recognition of this as a medical, a true medical use is moving away from this, treating it like a vice, like an alcohol type situation, and allowing it to grow in a moderated manner. And I think this makes sense. And the way that, the official code of Georgia annotated reads is by implication implicated in the 27-133.1. And I think by that standard alone, we've got a good level of protection from that floodgates being opened as a result of this small step forward. So I guess what I would say is, I have my feelings about the 2 miles. I have my feelings about medical marijuana in general. And I guess I'll let whatever motion comes before this board, I'll cast my vote whether I believe it's reasonable or not, but I would like to see that 2 miles reduced, if I were making the motion.
Mr. Chairman, if I could volunteer kind of like one fact, like a good way to think about distances could be in terms of, now we don't have city blocks in that sense, but you think of Midtown Atlanta, and not all the blocks are the same approximately too, but you have block sizes of 400 to 600 feet. And generally, like the smallest city blocks are typically something like 250 feet, and the largest city blocks are something like 1,000 feet. So maybe that helps, like visualizing distances, that like if you're like in Midtown somewhere, a block size is typically from intersection to intersection is typically something like 400, 500 feet.
Okay.
And based on the current map, if you were to change the distancing, you're only talking about the perimeter center district that's being impacted. As someone who lives in the perimeter center district, I wouldn't want there to be like a dozen of these in that location, or have it be open to having like a dozen of them in this location. Cause that's now like, yes, it will be a permitted use, but as someone who may like, that's taking away from another use that people who live in that area or work in that area could have.
So how many
access
would you
to.
allow in that location? Where the decision's solely yours to make? I know that, well, and again,
I
that's
mean,
the
I
tough
totally
question.
understand the argument of like not having a 2 mile radius, because that just limits it to 2 in that area. The 1 mile, you probably could get 3, but yeah.
But on that note, I mean, just thinking about it, because so we're talking about 1, 2, 3, 4 in our city. There could be 5 pharmacies dedicated specifically to medical marijuana. My question is how many do you need? That's 5 pharmacies for one specific therapeutic use, one specific drug.
Well, I think the market will determine that, will it not?
Yeah, well, and doctors and whatnot. So, and again, I think to Paul's point earlier, we can always come back and amend this. If you see the need, if you see that it's too restrictive, it's too limiting, this is something that, it may be a good starting point. It doesn't have to be the end point. But I would say kudos to the city for approaching it.
Okay, so is there a motion that anybody would care to put forth?
I move that we approve the amendment as written.
Commissioner Cameron moved that we approve the text amendment as it's been written, drafted, recommended by staff. Is that a correct statement of your motion? Is there a second to that motion?
Second.
Is that Commissioner Shin? Okay, Commissioner Shin seconded that. At this time, is there any discussion or debate among the commission? Okay, hearing a motion and a second at this time, it's appropriate to vote. All those in favor of approval of this motion, raise your hand. All opposed, like sign. Do we have 4 to 3? Is that what I saw? Okay, So 4-3, the motion carries, but is disputed. So at this point, the motion does carry. We'll move forward to other business. Paul, is there any other business?
There's not, and if I would summarize what happened at the meeting is that the 3 votes against were not against the use itself. They were more leaning towards a smaller radius. Would that be correct to the people who voted no?
I would say that is correct. And yeah, I would respectfully request that be included in the report to council. Thank you.
No other items.
Okay. And so hearing no other business, is there any public comment? I do not see any public here, so I will assume that there is no public comment. At this point, commission comment, we'll start all the way to my right and kind of work our way across. Any commission comment? Commission comment? All right. I'm going to take this opportunity really quickly on the record just to make a quick commission comment. I would urge council, this is not really our purview at this point, but I would urge council to begin taking a look at decriminalization efforts as well on the subject of marijuana and how that's handled and related social justice issues surrounding that. And so with that in mind and hearing nothing further, we'll adjourn. Thank you.